The Coalition Arbitration Court on Meridian Station had been settling interstellar disputes for 211 years. Its ruling accuracy, measured against later appeals across 12 species, sat at 91%, the highest of any tribunal in the outer systems. Its case archive filled 4 physical vaults, because the founding charter had insisted that judgment, once rendered, be touchable, printed, bound, and shelved, so that no ruling could later be quietly edited out of existence. In 211 years, no case had ever been resolved in under 3 hours. The station itself had been built for exactly this purpose. Neutral ground, owned by no member species, staffed by clerks rotated every 4 years so that no permanent loyalty could form between the court and any one delegation. The Threshold Accord, a dispute over mining rights along a shared asteroid belt between the Calvin Directorate and the Sendai Compact, had been open for 11 weeks. Both sides had filed briefs. The Calvin brief ran to 12 volumes, cross-referenced, indexed, and delivered under seal by a courier ship built for nothing else. The Sendai Compact's original legal office had withdrawn from the case in week 6, citing what their final memo called a volume problem, a polite way of saying they had been buried and knew it. Dane Osai was 34, from a mediation firm on the edge of human space that no one on the station had heard of, not even the clerks who processed his credentials. Arbitrator Meyerth Kahl had read his file twice, because the first pass produced a work history that did not match a man his age. 41 resolved territorial disputes, none of them public, all of them verified through the coalition's closed registry, a registry most delegates did not know existed. 3 of the 41 had ended in under a page. 1 had ended in a single sentence, appended as a footnote to a treaty that was still in force 9 years later. Kahl had pulled that footnote and read it 4 times before deciding it wasn't a clerical error. Osai had been brought in on 11 days' notice, at the Sendai Compact's request, after their original counsel walked away. He arrived at Meridian Station carrying a single case, checked it at the door for scanning, and found his quarters without asking anyone for directions. He spent his first 2 days reading, not the 12 Calvin volumes cover to cover, but their footnotes, their appendices, the parts of a brief that get filed and never revisited. He did not attend the welcome reception the station's protocol office held for new counsel. He did not mention the 41 disputes. He did not mention anything. The hearing room held 80 seats, and by the 3rd day of testimony, all of them were full. Word had moved through the station's other delegations that something unusual was happening in the Threshold case, though no one could say exactly what. The Calvin Directorate had sent a legal team of 31, the largest delegation the court had fielded in a decade, led by Chief Counsel Ashra Vantrell, 4th-generation litigator, undefeated in coalition arbitration for 16 years. Her team occupied 2 full rows. Behind them sat associates whose only job was carrying the physical volumes from table to table, because Vantrell preferred paper for anything she intended to cite aloud, printed argument. She had said once in an interview the court archive still had on file, could not be quietly revised after the fact. On the 3rd day, Vantrell introduced her closing challenge the way certain counsel introduce a challenge they have already won, with the timing and tone of someone who has rehearsed the room's reaction as carefully as the words themselves. She stood, gestured toward the 12 volumes stacked at her table, and asked, in a voice pitched for the whole room rather than just the bench, whether the Sendai representative wished to present a comparable brief before the tribunal moved to close arguments. Several members of her team smiled. It was the kind of smile that happens in rooms where a hierarchy has already been assumed settled, not cruelty, just certainty, which in a room like that one amounted to the same thing. "We have a response," Osai said, in the tone of someone who found the question entirely reasonable. He did not stand. He opened the case at his feet, removed a single sheet of paper, and set it on the table in front of him, squaring its edge against the table's edge before he spoke again. One paragraph, with the tribunal like it read aloud or entered into record first. A few of the associates in the second Calvin row laughed, quietly, the way people laugh when they think a joke has already landed. Vantrell did not laugh. She had spent 16 years learning to read a room before it finished forming an opinion, and something about the way Osai had squared the paper's edge told her this was not a bluff being called. Arbitrator Call, at the head of the chamber, said nothing. She had asked for the case file 11 days ago. She had been waiting for this moment since the first afternoon of testimony when she had noticed, and only she had noticed, that Os had not once objected to a Calvin filing, only read it. The reading took 40 seconds. The paragraph did not challenge the Calvin claim to the outer belt. It conceded it cleanly in the second sentence. Then, in the third sentence, it cited a boundary clause buried in Appendix 9 of the Calvin's own 12 volumes, a clause the Calvin's founding charter had never repealed. Inherited from an older treaty, their legal office had copied forward out of habit rather than intention, which required any claimant exercising extraction rights in a shared belt to offer co-development terms to any prior resident population before final registration. The fourth sentence named the Sendrai mining outpost that had existed in that belt for 60 years, its registry number, and the date of its founding. The paragraph did not argue that the Calvin claim was wrong. It argued that it was already, by the Calvin's own law, conditional, and had been the whole time, sitting in a footnote no one had thought worth reading twice. The room did not react immediately. It reacted the way a held breath releases. The front row first, then the rows behind it, the sound of 31 people simultaneously turning pages they had written themselves, looking for the clause, and finding it exactly where Osai had said it was. Vantrell did not sit down. She stood very still, holding the volume open to Appendix 9, reading a sentence her own team had filed into the record 11 weeks earlier without anyone flagging what it meant. This was not a woman losing an argument. This was a woman recalculating the last 11 weeks, and possibly several years before them, against 4 new sentences. Arbitrator Call allowed the record to show the exhibit, and then did something the court's own procedure did not strictly require. She asked her clerk to display the case history for the specific clause, Appendix 9, Section 4, across the room's view screens. 4 prior rulings appeared, spanning 60 years, from 3 different tribunals, each one turning on the exact same co-development clause, each one a case the Calvin's own legal office had cited in other disputes when the clause worked in their favor. The first ruling was a border case between 2 mining consortia on a belt near Threl, decided 19 years earlier, where a claimant's failure to offer co-development terms had voided a registration worth several years of extraction revenue. The second was a fishing rights dispute in a shared reef system, where the same clause had been the deciding factor in a case Vantrell herself had argued successfully for the claimant invoking it, a fact 2 of her own associates had apparently forgotten, judging by the pages they were still turning. The third was smaller, a survey rights disagreement resolved out of court entirely once the clause was simply raised in a filing, never reaching a hearing at all. The fourth was recent enough that 2 of the junior counsel at Vantrell's table had cited it in their own footnotes, 3 volumes back, without connecting it to their present case. A detail the clerk noted for the record without being asked to. By the third ruling on the screen, Vantrell was not reading anymore. She was watching the display with the expression of someone doing arithmetic that was going to take longer than the hearing had left in it. Behind her, the smiles from the opening challenge were gone. Not embarrassed, recalculating. The room was silent in the specific way rooms go silent when 31 trained professionals realize, at the same moment, that the document they spent 11 weeks building had contained its own answer since the day it was filed, and had in fact already answered 3 other disputes over 60 years without anyone connecting the pattern. Osai did not speak during any of it. He sat with his hands folded on the table, watching the screens with the room, the single sheet of paper still in front of him, face down now, its work finished. Somewhere behind him, one of the Colvin associates quietly closed Volume 9 and did not open it again. Vantral closed Appendix 9 herself, a moment later, more deliberately. She did not ask for a recess. She did not ask to strike the exhibit. She looked at her own citation, then at the paragraph on Osai's table, then, briefly, at the 4 rulings still lit on the screen behind the bench, and said the only thing the moment required. "We wrote the clause that beat us." No one in her row said anything back to her. She gathered her team with a small motion of her hand, no announcement, no concession speech, and the 31 filed out over the next several minutes in the particular quiet of people rereading their own work on the way to the door. Vantral was the last to leave. At the door she paused, one hand against the frame. "Co-development terms instead of denial," she said. "We could have offered that in week 1 and kept the timeline." "You still can," Osai said. "The clause doesn't close the door. It just says who has to knock." She did not answer that. She looked at him for a moment longer than the exchange required, the way a person looks at a problem they intend to study later, and then she left. Osai stood, closed his case, the same one he had checked at the door 11 days earlier, worn at the corners the way something gets worn from use rather than age, and walked out through the side entrance the way he'd walked in, without anyone stopping him to shake his hand. Outside in the corridor, a junior Sendrai attaché tried to ask him a question about the co-development terms and their timeline. Os answered it in 4 sentences, the same economy he'd used in the hearing room, and kept walking. Arbitrator Kahl remained after the room had cleared, alone with the clerk, and the 4 rulings still glowing faintly on the screen before someone finally powered it down. She opened the court's case log, the record that would follow this dispute into the archive alongside 211 years of prior rulings, and entered the closing note in the field marked Outcome. She considered the sentence for a moment, the way she considered every closing note, and then decided the case did not need one.